litigation brought by the states at its essence is about our nation's founding principles of limited government and individual liberty. The Founding Fathers set up specific enumerated powers of Congress in our Constitution to allow for states to have a role in the system of federalism, as well as to retain certain freedoms of individuals. The federal health care law tramples on these founding principles. The state's lawsuit makes essentially two challenges. First, on the individual mandate, and second, in regard to state sovereignty. On the individual mandate, states claim that the federal health care law exceeds Congress's authority under the Commerce Clause in particular. At bottom, the lawsuit alleges that the U.S. Constitution does not provide the federal government the power to force an individual to engage in activity or to be penalized for inactivity when that individual is not already in interstate commerce or substantially affecting interstate commerce. Furthermore, in the Department of Justice's brief, they argue that the individual mandate is instead a tax, in contradiction to statements the President made last fall that the individual mandate would not be a tax. But nonetheless, the states, in responding to that, believe it's an unconstitutional direct tax in violation of Article 1, Section 9 of the Constitution. And basically, an individual mandate penalizes an American who chooses not to purchase health insurance. We call it a tax on doing nothing. Second, the state's lawsuit challenges the federal health care law due to its infringement on state sovereignty in violation of the Constitution. The Federal Health Care Act directly harms states, enabling the federal government to coerce states and to manipulate state resources in unprecedented ways. Like briefly, just to touch on 5 ways that that occurs. 1, in passing on large additional Medicaid costs on the states, vast new coverage requirements, new administrative and oversight costs, higher reimbursement rates. 2nd, providing in the Medicaid program for a gross expansion of government bureaucracy. 3rd, altering the Medicaid program significantly in a way that makes it financially infeasible for states to remain in the program, but providing no means for states, except through the Medicaid program, to cover the poor, those below the federal poverty line. 4th, intruding on the state regulatory process and co-opting state resources by requiring the insurance exchange and provider networks. And 5th, imposing a mandate on states as employers to have certain health care benefits for state officers and state employees. This burden comes at a time when all states face severe budget cuts to offset those shortfalls in already difficult economic times. And just to wrap up, the state's lawsuit is simply about the constitutional limits being exceeded by the federal government to the detriment of state budgets and taxpayers. The attorneys general and states have an obligation to assert our state sovereignty, to defend individual liberty, and to uphold the Constitution.